Hi everyone, in this lecture we're going to be discussing Chapter 8. In Chapter 8, the focus is on patient record requirements. Alright, so to begin, brief introduction here. The health information that's contained in paper health records, electronic health records, or an abstract of patient-specific information or some other format plays a primary role in the delivery of care. In addition to its role in direct patient care, health information maintained in these types of formats serve as the healthcare provider's legal record of patient care. As such, it's subject to stringent legal requirements. So to understand legal requirements that govern the health record, those who are interested in protected health information should first recognize its function and its uses. Functions and uses are affected by statutory, regulatory, accrediting, and institutional requirements. By understanding these concepts, effective policies that govern the health record content, retention, and destruction can be created. In general, the health record is a document that contains a complete and accurate description of a patient's history, condition, diagnostic and therapeutic treatment, and the results of treatment. The health record includes detailed personal, medical, financial, and social data about the patient. Health records include detailed personal, medical, financial, and social data about patients. And the health record also serves both clinical and non-clinical uses. Some clinical uses of the health records include direct patient care, chronological documentation of care, method of cross-discipline education, research activities, public health monitoring, and quality improvement activities. Some examples of non-clinical uses of the health record include billing and reimbursement, verification of disabilities, and it serves as the legal document of care. The health record as a legal document has traditionally been viewed as being paper-based. However, since we are at the digital age, healthcare providers have been faced with transforming their traditional paper records into the electronic health record medium. In addition to paper and electronic health records, you can see that some providers have hybrid records, which consist of both a mix of both paper and electronic means. Regardless of the medium in which the data resides, the concept of a legal health record focuses on its definition, where the business record generated at or by the healthcare provider or the organization that addresses the patient's episode of care that was delivered by the provider or organization. The transition from the paper world to the electronic world has surely generated complexity as to what is considered the legal health record, especially in light of the lack of clarity in statutes, regulations, and standards that address electronically stored information. Unfortunately, no one source of law definitively addresses the legal requirements that govern the content of health records. Instead, there's a myriad of sources that supply these requirements, and they include statutory, regulatory, accrediting, institutional, and professional guidelines. Although each source is separate, they must all be reviewed together in order to obtain an understanding of the legal requirements that govern health records. In any review of the legal requirements that govern health records, we have to be concerned with statutory provisions. Although there are very few statutes address the contents of health records specifically, statutory provisions should be reviewed first because of their critical role they play in the legal system. Statutory provisions can be federal or state laws or municipal codes. Unfortunately, no one federal law addresses the legal requirements that govern all patient records. Instead, it's a small patchwork of federal and state laws on this subject that exist. States have passed statutes that refer to health records generally. However, they limit the statute to the requirement that the healthcare provider merely creates a health record. If the content of the health record is defined by the statute, the definition is often provided in the context of hospital licensing. Closely related to statutory provisions are regulations that are promulgated by executive branch agencies. Frequently, statutory provisions delegate certain powers to the executive branch agency that is responsible for licensing a healthcare facility, such as the power to promulgate and enforce rules and regulations that govern the healthcare facility's health records. Found at both the federal and state levels, these regulations vary between general statements that a health record be maintained, broad listings of content requirements, and specific, detailed provisions that govern the content. Some states may choose to adopt CMS requirements while others adopt accreditation standards through the Joint Commission. Here, you will see an example of a specific detail that's in regulation as it relates to the CMS conditions of participation, as it applies to healthcare organizations, mainly think hospitals here. The medical record must contain information to justify the admission and continued hospitalization that support the diagnosis and describe the patient's progressive and response to medications and services. It must be legible, complete, dated, timed, and authenticated in written or electronic form by the person that's responsible for providing or evaluating services. Although accrediting standards do not have the force of law standing alone, they are frequently used to establish the standard of care in negligence actions against healthcare providers. At least 2 states have adopted accrediting standards as their governing regulations. Healthcare providers must pay close attention to these standards of accreditation. 2 widely recognized accrediting bodies in healthcare are the Joint Commission and the AOA, which is the American Osteopathic Associations of Healthcare Facilities accreditation program. A newer organization is also the Det Norsk Veritas, the DNV. Healthcare has recently entered the accrediting market in the U.S. All 3 bodies have been granted deeming authority by CMS to conduct accreditation surveys. With regards to deeming authority, the deeming authority means that compliance with the requirements and standards of both the accrediting organization may substitute for compliance with the federal government's Medicare Conditions of Participations for Hospitals that has been published by CMS. Accreditation by any of these organizations often enhances a healthcare facility's public image, competitiveness, and ability to borrow money or float bond issues. Each of the accrediting organizations has issued standards requiring hospitals to maintain health records for each patient and describe in detail the contents of the health record. Additional accrediting bodies do exist that often cover specialized areas of healthcare. This could be, for example, rehab industries, mental health, things of that nature. Where there's no specific statute or regulation that specifically addresses the existence or content of a health record, healthcare organizations may wish to create their own standards or adopt the standards that are issued by an accrediting agency. These institutional standards may be broad statements or detailed listings or fall somewhere in between. They serve more as a guide to health record content for that institution. Institutional standards do not carry the force of law. However, they are useful to establish the standard of care in negligence action. In addition to the sources that we discussed, there are professional guidelines to adhere to address the existence and content of health records. For example, AHIMA publishes position statements and practice briefs that regard health record content. Although healthcare associations are not providing legal advice when publishing these guidelines and position statements, The documents do address sensitive legal issues that are related to health records. As such, they assist health information managers and directors in ensuring accurate and complete health records. As we had discussed earlier, a health record serves multiple functions and uses. It's important that a health record be timely and complete to be essential to achieving these purposes. All records must be authored and authenticated. Authorship identifies that a healthcare provider who have made the entry either in writing, by dictation, keyboard, or by keyless data entry. Authentication, on the other hand, confirms the content of the entry either by written signature, initials, or computer generalized signature code. This confirmation implies that the entry, as recorded, is accurate. The concept of authorship has become more challenging with the rise of electronic health records. Unless designed to prevent an occurrence, the ability to copy and paste portions of the health record does exist in the electronic health record. As such, actions may result in a host of different problems, including misidentifying who is making an entry, placing portions of one person's health record in another person's health record, mistakenly adding services on dates when services were not rendered, and inadvertently repeating entries that are no longer accurate. These, as well as other problems, can present serious compromise to the integrity of the record. To reduce the risk, healthcare providers and the organizations should create policies and procedures to address the use of copy and paste functions and to train their staff accordingly. In addition, rubber stamp signatures, when we're talking about paper copies, may be prohibited by accrediting bodies. CMS may, however, accept physician signatures that are handwritten, electronic, or facsimile. Additionally, the medical record must be complete. Only the author of an entry may authenticate that health record, and the record must be reliable. It has to be made by the person who had that firsthand knowledge, made at or near the time of the actual occurrence event, so it's timely. Medical advice that's exchanged through different means of electronic needs to be entered as well, and medical information does not. Reliability with health records is critical. It ensures delivery of quality care. It works together to meet licensing and accreditation requirements and admission of a record into evidence in legal action. So it is important that the information contained in the health record not only be timely and complete, but that it be reliable. Without a complete health record, a healthcare provider's ability to render quality patient care and conduct research and education is impaired. In addition, a healthcare provider's ability to present a defense in a lawsuit is called into question. Incomplete records, as we mentioned, impairs the quality of patient care, impairs the provider's defense against lawsuit, and may violate laws and accreditation standards. The role of a health information manager and director is to identify and attend to any deficiencies of health record content, as well as complete concurrent and post-discharge chart reviews. Remember, in healthcare, if it wasn't documented, it was not completed. It was not done. No matter how careful a healthcare provider is, we all do make mistakes at times. Details of a patient care may be incorrectly recorded, and perhaps the patient information that is recorded is in the wrong patient's health record, or the words are misspelled. When these mistakes do occur, it is appropriate for the person who made the original entry to make corrections to the record. In paper world, corrections are made by drawing a single line through the error, writing error beside it, as well as the date, time, and initial. And what you want to be sure to do is to never fully cross out and obliterate the error. With regards to corrections being made to electronic health record, the same principles do apply. However, it's a different system because we're no longer on the pen and paper track. We're more electronic. So what needs to be done is as an addendum to the health record is needed with reference to the original entry, and standard organizations have issued guidelines on how to go about preparing corrections in the electronic world. Healthcare providers are relying on the information that is found in the health record. It's important never to delete data from record, and in addition, because the deleting compromises the integrity of the record. Corrections of the record may be made by patients. Under HIPAA, a patient has a right to request an amendment to their record. If the entity, the healthcare organization or provider's practice, agrees to request an informed patient and insert the amendment. A provider may deny this request for some specific reasons, and state laws may establish patient rights. The retention of health information has been influenced by both external and internal forces. There are certain statutes and regulations that provide specific requirements on record retention. The ability of a healthcare provider to meet the needs of continuing patient care, education, research, and defense of professional liability actions influences how long health information should be retained. Furthermore, storage constraints, new technology, and fiscal concerns play a role in reaching a decision on this issue. In HIM, you must be able to reconcile these forces when creating effective record retention policies. Record retention policies are the general principles that determine the length of time health data and health records in which those data are stored must be maintained by the healthcare provider. Decisions reached on questions like these result in establishment of a record retention schedule, a document that details what data must be retained, the retention period, and the manner in which the data will be stored. Data storage choices include paper files, microfilm, magnetic tape, optical discs, and electronic systems, including archiving systems. Whatever choice made, the healthcare organization's health record retention policy and retention schedule must necessarily address the legal requirements in addition to the institutional needs. Statutes on the state level and regulations on both the state and federal levels address retention requirements. For example, some state statutes establish specific time frames for which to retain the health record following the death or discharge of a patient. These time frames may differ if the patient is an adult or a minor or has a mental disability. Usually, it is regulations rather than statutes that provide the specific time frames. On the federal level, the conditions of participation in the Medicare program require hospitals to maintain health records for the period of the state's applicable statute of limitations, or if there is no applicable statute, for 5 years after discharge. Statutes of limitations in contract and tort actions also influence retention decisions because the ability to defend a lawsuit successfully depends in part on the availability of the health record. An additional area that deserves attention is the retention of healthcare business records. These business records may include book of accounts, vouchers, canceled checks, personnel and payroll documents, sales records, compliance documents, and correspondence, or just to name a few. Retention requirements for these types of records are based on statutes and regulations at both the federal and state levels. As with health data, the business record retention policies must encompass all forms of media in which the business record is created or stored, including paper and electronic records. One regulation that healthcare organizations must consider when developing a business record retention policy deals with the HIPAA requirement that covered entities must retain records showing HIPAA compliance for a period of 6 years. Such records include those documents that demonstrate the integrity and effectiveness of the compliance program and may include audit and monitoring results, internal investigations, hotline reports, documentation of employee training, and the original details of the compliance program, plus any modifications and self-disclosures. In addition, AHIMA and the AHA recommend retention of health records for a period of 10 years. They look at the adult patient records from their date of last visit and any additional concerns related to children retained to age of majority, plus the statute of a limitation period. Another external force that should be considered in a retention discussion is new technology. The increased use of electronic health records has caused many in the healthcare field to reconsider policies related to record retention. In contrast to paper-based records, electronic health records offer the advantage of not requiring as much physical storage space. Guidelines that address creating, identifying, retaining, retrieving, and destroying electronic data can be found in detail in the textbook of Chapter 8. Because of the storage space advantage, many healthcare providers are tempted to retain electronically stored information longer than required by statute or regulations. However, policies should be in place that address the specific process for creating and retrieving data, what exactly information should be stored, and the reasonable retention time period. Retention policies that govern electronic health records should address what information should be retained and for how long, just as policies that govern paper-based records do. Policies should be realistic, practical, and tailored to the needs of the healthcare organization. One emerging development to combat the potential for increased costs associated with the legal discovery process of electronic health records is Enterprise Content and Record Management, ECRM. Enterprise Content and Record Management addresses both electronic record management principles and enterprise content management principles. It encompasses both traditional health record management plus the management of newer clinical content, including email, voice, text, and speech files, as well as non-clinical content, things like financial and administrative data. By viewing all data and records from an enterprise perspective, retention of data and records is managed systematically, and the potential increases for a more streamlined process of responding to e-discovery requests. Every healthcare organization that retains health records faces the prospect of destroying those records at some future date. When this time arrives, the institution should have in place a policy that governs their destruction. Destruction of health records occurs in any of 3 instances, whereas the destruction of medical records in the ordinary course or due to provider's closure. Record destruction policies should address, at minimum, the controlling statute and regulation. The controlling statutes and regulations may specify or recommend the method of destruction, for example, shredding, burning, or recycling. The HIPAA security rule has a requirement that effective information and security policies encompass the concept of handling data destruction. In a healthcare organization's destruction policy of health records, the methods should be specified in the policy. For example, if it's paper-based health record, Shredding, burning, dissolving an acid so data is unreadable or indecipherable, or recycling is a proper means of destruction. Electronic media, including hardware, include magnetic degaussing or overwriting non-sensitive data, destruction of backup tapes or other media as well. So destruction methods for both paper and electronic means should be detailed in the policy. After a retention period has expired, the timing should also be outlined in the policy. Certificate of destruction is the document that shows what data and records were destroyed, who destroyed those data and records, and the method used for destruction. These certificates are important if the destruction is performed by a third party pursuant to an outsourcing contract because of the healthcare organization's possession a duty to ensure that the contracting agent follows the instructions outlined in the contract's terms for handling and processing data and records. These certificates serve the purpose of defending a healthcare provider in an investigation before a governmental agency or in a medical malpractice lawsuit in which the absence of a health record is an issue. The destruction of health data and records may also occur because of a change in ownership of a healthcare provider or an organization. Contrary to the reality of decades past, many providers and organizations participate in numerous ownership arrangements. These arrangements frequently specify the health data and records are considered the property and assets of the owners and are subject to the contractual terms upon which the owners have agreed. When one of the owners dies, retires, or otherwise ceases to participate in ownership by leaving the practice or organization, the terms of the contractual agreement will address what happens to the health data and records to the departing owner created, including whether the data or records will be destroyed. Ownership change meets the definition of healthcare operations under HIPAA. HIPAA's privacy rule states to maintain the confidentiality of individuals is paramount, and that civil fines and punishment for breach of this does exist. Contracts with commercial vendors, including the method of destruction, safeguards to be followed to maintain privacy, also exist. Reasons for health record destruction include the ordinary course of business from day-to-day operations, ownership change, and due to closure or dissolution of practice. Destruction policies are going to outline or should outline what to do and when to do it. At this time, we have completed the discussion for Chapter 8, Patient Record Requirements, and we will move on to the next chapter that will detail confidentiality and informed consent. Thank you.